And I will chair the meeting this morning, and I hereby call the meeting to order. This morning there is a public meeting scheduled for 2 consents and 1 minor variance application. I will briefly summarize the procedure to be utilized for the meeting. First, the Secretary-Treasurer will advise the committee as to when, how, and to whom notice of each of the application was circulated. Next, each of the applications will be considered separately. Planning staff will advise you of the purpose and effect of the applications and provide any other information that is relevant. The Secretary-Treasurer will summarize any correspondence on file. From there, the applicant may make a brief presentation if they so choose, and the public will have an opportunity to speak to the applications being considered. After the public forum, the committee will then deliberate on the proposed applications and consider a motion to pass, defeat, or defer the decision for the applications. The consent and minor variance applications being considered this morning are B18/29 for 985 Harrison Trail, B1901 for 189 John Buckler Road, and A1845 for 20 Ireland 1900 in Georgian Bay. Are there any declarations of pecuniary interest? Seeing none, I will ask the Secretary-Treasurer to let us know about any correspondence.
Thank you, Chair. Notice of each of the applications was sent by first-class mail to the respective owners and assessed persons within 120 meters, 500 meters, or 800 meters, and to those persons and agencies likely to have an interest in the application. The notices were sent at least 20 days prior to this morning's meeting. Included in each notice was an explanation of the purpose and effect of the application and a key map showing the location of the property. Other relevant information may also have been provided. These circulations were provided in accordance with the provisions of the Planning Act 1990.
Thank you. Our first application is B1829 for 983 Harrison Trail. To the planner.
Excuse me, Mr. Chair.
You forget about me already.
Would you please step forward and identify yourself? Yes, I believe our clerk has some comments for us.
Well, I did have comments for you. For the ones who don't know me, I'm Jessica Gunby. I'm the clerk here at the Township. The Code of Conduct that the Secretary-Treasurer sent you on Thursday, I'm here to discuss if you have any questions about it. As of March 1st, the Committee of Adjustment is one of the committees that now has to abide by the Code of Conduct that Council just approved at our last meeting. I was told this morning, though, that you were very good little committee members and read it all and have no questions. But if you have any questions, I'd be happy to answer them for you. And I knew you were going to have one.
I think we should have a test for these members, just to make sure they read it.
Okay.
No, I'm kidding.
What's the maximum amount of a bribe you can take?
You're
0.
being recorded, Jessica.
That's right. So are you. So, so the Code of Conduct just outlines promoting public trust, upholding confidence, and the first page basically states that you conduct yourself in a manner that is above reproach, and you conduct yourself in public and in respect to the public in such a way as it reflects the decorum and dignity of the office that you hold. It's pretty self-explanatory, but again, if you have any questions, you can let me know, and if you have any questions later on about it, you can just send me an email and I'd be happy to answer them for you and reply to all so you all have the right information.
Thank you very much, Ms. Gunby.
You're very welcome.
So if we could again look at our first application for today, which is B1829 for 983 Harrison Trail. Ms. Lemieux.
Good morning and welcome to our new committee members. My name is Victoria Lemieux. I'm a planner here with the Township. So our first application here is B1829, which was applied for by John Jackson Planning on behalf of Towcon Holdings regarding lands located at 983 Harrison Trail. So this application requests to grant an easement in favor of the neighboring lands at 987 Harrison Trail to recognize the existing vehicular access through the subject lands. So here we have a location map of the property. It is located on 12 Mile Bay. Surrounding lands include, of course, similar residential lots to the east and west, with Crown to the north. So the lands are currently designated waterfront in the official plan and are zoned shoreline residential type 1 in the zoning bylaw. So here we have an aerial of the subject property, and as previously mentioned, this application intends to legalize the access for this lot here, which has the star beside it. So this driveway, you can kind of see through the aerial here, this is where the easement would be granted over that driveway to give them that legal access through the subject lands. And so here we have the survey showing where that existing driveway is located. And again, Harrison Trail is here for reference. And essentially this is just to provide 987 Harrison Trail with that legal access over the driveway, which is how they've been accessing the property, to my understanding, since the main structures were built on the property. So here we have a couple pictures. The snow was pretty heavy that day, so there's not a lot to see other than some snow, but here, Harrison Trail, we're looking towards down that driveway. And here we're at essentially the tip of the driveway that then curves down towards the neighbors, looking out to 12 Mile Bay. And again, just looking out 12 Mile Bay at the edge of that driveway. And so this is, you can see how how quite steep the property is located, and the driveway comes down here and the neighboring property is back there. I was not going to snowshoe myself over there, unfortunately, so I apologize for that. Maybe another time. And this is the property located to the west, just showing that there is an accessory structure relatively close to that existing driveway, but again, no use is changing here. It's just legalizing what's already existing, so there doesn't, there's not going to be any negative impact to the adjacent lands. And then again, looking towards Harrison Trail, looking north here. So the township official plan states that under section I.4.2 that consents may be granted for technical or legal reasons, such as boundary adjustments, lot additions, right-of-ways, and easements. The application proposes to legalize an existing access to developed lands, and no new access onto Harrison Trail is proposed through this application. So the application conforms to the district and township official plans and maintains the general intent of the zoning bylaw, and staff does recommend approval of the application. If you have any questions for myself, or the applicant's agent is here as well for any questions. Thank you.
Thank you, Victoria. Does the applicant wish to add anything to Victoria's comments?
Morning, Mr. Chairman, ladies and gentlemen.
Please step forward and identify
Where do you
yourself.
stand in this new layout?
Please sit in front of the microphone and identify yourself, please, for the
Thank
secretary.
you. My name is John Jackson, principal of John Jackson. Is this on? The application, I think, has been characterized pretty accurately by Victoria. Simply put, the applicant owns 2 lots on 12 Mile Bay. Actually, my client has purchased one of them. The existing driveway, as Victoria's described it, has been in use for a number of decades, but it's never actually been formalized when it was owned by the current owner. And my client's quite eager to regularize it so that she has the legitimate right-of-way, and wants to be able to do it because as soon as she possibly can, because the second lot owned by the applicant is currently up for sale. She has a contract to get it through the current owner, and is concerned that the second property sells, it may not be as seamless. So it's quite a simple application, but quite important to the new owner of the lot. So if you have any questions, Mr. Chairman, I'd be happy to try and answer them.
Okay, thank you very much, Mr. Jackson. Are there any other members of the public that would like to comment on this application? Okay, let's see. Has there been any correspondence on this application?
The District of Muskoka has no objections.
Thank you. Seeing no further comment from the public, I'll bring this application before the committee. Are there any questions or comments of the planner? Member Matthews.
Thank you, Mr. Chair. Just for my own clarity, the current, the two lots are owned by one individual at this point in time? Or-
Through you, Mr. Chair, it's my understanding that the applicant Taucon owns 983, and the adjacent owner here essentially wants to legalize this access prior to this lot going up for sale. Is that correct? And it's the lot on the other side that Taucon also owns?
And yeah, through Mr. Chair, my client Elizabeth Keenan owns lot 64 that she purchased from Taucon, the current applicant. So that deal had closed. She closed it somewhat prematurely, but on the condition that she'd get the right of way. So both 63 and 64 were owned by the applicant. Ms. Keenan, my client, bought 64 and now wants to regularize the driveway over the retained lot 63, which is also up for sale and likely to be sold imminently.
I guess the point that I'm driving to is both people are in support of this application, I take it, right?
Mr. Chair, yes, that is correct.
Okay, thank you.
Any other questions or comments? Okay, seeing none, I will call the vote.
Read the motion.
Very well, I'll read the motion. Be it resolved that the Township of Georgian Bay Committee of Adjustment approves consent application B18-29 to grant an easement in favor of the neighboring lands 987 Harrison Trail to recognize the existing vehicular access through the subject lands at 983 Harrison Trail, subject to the following. Deeds for the easement are submitted to the Secretary Treasurer along with a registered copy of the survey plan. A complete set of digital drawings, files of the reference plan shall be provided to the Township of Georgian Bay. All those in favor? Carried. Our next application is B19-01 for 189 John Buckler Road to the planner.
So our next application was submitted by Oscar Singer on behalf of Walter Bamford regarding lands at 189 John Buckler Road. And this application requests to facilitate a lot boundary adjustment to eliminate a parcel of land, which is the subject lands, and add a portion of the lands to the adjacent land parcels, 183 and 197 John Buckler Road, to increase their lot area and lot frontages. So here we have a location map of the subject lands, which is located on 6 Mile Channel. The lands are designated waterfront in the official plan and currently zoned shoreline residential type 1. They are accessed by John Buckler Road, which is privately owned and maintained. So here we have an aerial photo of the subject lands. So the subject lands are approximately highlighted here in red, with the stars on either side essentially just illustrating the boundary adjustment would be to provide additional lands to both sides here. So there are no structures that currently exist on the subject lands. It is a vacant property. So here is the proposed plan of the boundary adjustment. So here we have severed parcel A, or proposed severed parcel A, which would be added to the lands at 183 John Buckler Road. And the remainder of the parcel would be added to 197 John Buckler Road. It is important to note here, as you can see, there is this easement located here on the survey. The property at 197 John Buckler Road, it is quite steep, and there was, when they purchased the property, an existing driveway that existed that went over through the subject land. So that had been legalized in the past. I believe it was in 2000 or 2002. So this property here, 197, the reason why this is carved out like this is to essentially allow them to finally get ownership of the driveway that they've been using to access their property for the last however many years. So here we have just a table of the overview to the changes of the lots that's proposed. So 183 John Buckler Road, which is the property to the west, would be increasing in area by 0.4 hectares and increase in lot frontage along the water with 24 meters of an increase. And 197 John Buckler Road, which is that property with that easement and that long winding driveway, would increase by 0.24 hectares in area and add 16 meters of frontage along their shoreline. So here we have a couple photos just to try and give a bit of context here. So this is kind of the winding driveway that you see here, and this would be this corner here of the proposed severed parcel A. That would kind of be that back corner there, so you can see how the driveway is carved out. So again, that driveway coming around, and this would essentially be the new property boundary, and this area would be added to 183 John Buckler. Here we are on the subject lands looking towards 197 John Buckler Road, again, that property that uses the steep driveway, just for context purposes, again, of that very steep slope. And here we're looking at the shoreline. So this essentially, currently right now, this is the shoreline of the subject lands. This portion of the frontage would then be added to the lands to the east. And this portion here would be the new lot line, and this part of the frontage would be added to the other property. So again, here we have 197 John Buckler Road. Here approximately is the subject lands frontage. And then again, on the edge there is that remaining property. So this portion of that frontage would now be split into 2 lots. So essentially going from 3 lots of frontage down to 2. So again, section I.4.22 of the official plan permits consents for lot adjustment purposes. No new lot is being created through this application, and 2 undersized lots will become closer into conformity with the zoning requirements of the current zone. However, they still will be undersized, but again, it's just adding to their conformity much closer. So the application conforms to the district and township official plans and complies to the zoning bylaw. Staff are supportive of this application. If you have any questions, one of the neighboring landowners is here for any questions, and myself. Thank you.
Thank you, Ms. Lemieux. Has there been any correspondence on this application?
The District of Muskoka has no objections.
Thank you. Is there any member of the public that would like to comment on this application? Okay, seeing none, I'll bring the application before the committee. Are there any questions or comments on this application? If the applicant is present, are there any comments that they would like to add to what Ms. Lemieux had to say?
I'm just here for any questions that somebody might have. I'm Elizabeth Bamford. I'm the daughter of the owner. We have our property on the other side. Yeah, no, I just wanted to say that I was in support.
Okay.
Yeah.
Just
I was just saying I was in support.
we need to know your name, please, for the record.
Elizabeth Bamford. So I'm the daughter, so we own a property on the other side of 183 as well. And yeah, the neighbors are buying it, so we're in support.
Okay, did you own just this property, or do you have the other property next to it as well?
We used to own the neighboring 197 as well. So when we bought it, like 197 is sort of steep, so we bought the. So my father had put a driveway, sort of a winding driveway across, and I believe that's why they were severed it in that particular way, is because of the driveway.
Right, okay. All right, thank you very much. Coming back to the committee, we have a question from Member Cooper.
It's actually a comment, and I'm just delighted to see that less intensification versus more, so it's very nice to see. Thank you.
Are there any other questions or comments? Okay, I will read the motion. Be it resolved that the Township of Georgian Bay Committee of Adjustment approves consent application B19-01 to facilitate a lot boundary adjustment to eliminate a parcel of land and add a portion of the lot to the adjacent land parcels on either side, 183 and 187 John Buckler Road, to increase their total areas for 189 John Buckler Road, subject to the following. That deeds for the lot addition be submitted to the Secretary Treasurer along with a registered copy of the survey plan. That the proposed severed parcel A be added to the abutting lands to the northwest, and the proposed severed parcel B be added to the abutting lands to the southeast. And that section 50, subsection 3, paragraph 5 of the Planning Act, RSO 1990, chapter P13 be applied to all future transactions within the property. And 3, that a complete set of digital drawing files of the reference plan shall be provided to the Township of Georgian Bay. All those in favor? The motion is carried. Our next application is A1845 for 20 Island 1900 in Georgian Bay. To the planner.
Good morning. So for our new committee members, my name is Dana Suddaby, and I am another planner here with the Township. So our only minor variance application today is A1845. The applicant is Leslie Steiner, and the address is 20 Island 1900 in Georgian Bay, and the application is within Cognasheen. The request is to permit a decrease in the minimum required setback from the high water mark. So in Georgian Bay, the high water mark is the contour elevation 177.4 to a dwelling where 20 meters is required to 14.8 meters to facilitate the construction of a new dwelling. The land is currently vacant. There was a hold on the property, and that was removed October 9th of 2018. To give you an idea of the subject lands, it is located here in black, and it is designated waterfront within the district official plan, as well as waterfront within the Cognasheen Coastal Waterfront Community within our township official plan. And it is zoned Cognasheen Shoreline Residential Island. To give you an aerial view of the subject lands and the surrounding property, so as you can see, there is significant mature vegetation on the lands. I have a survey showing where the high water mark goes, but just to give you an idea on the aerial, the high water mark follows along the shoreline, and there is an area of low land between these two adjoining properties where the high water mark does cross the land and the location of the interior side yard setback. Just an overview of the entire survey. I do have a closer up on the following slide, but I just wanted to give you an idea of the entire lands. So there have been some comments received in regards to the septic system. So a building permit has been issued for the septic system as well as the dwelling in a location that complied with the zoning bylaw. So the septic is located here, and it complies with both the township zoning bylaw as well as with the building code since the permit has been issued. And there were some concerns raised about relocating the proposed dwelling. So it is an existing pan abode that was on a neighboring property. Since a permit has been issued, it is up to building code and would go through all of the required inspections along the way. So just to give you a better idea of the site plan. So the high water mark is this black solid line here. And they are requesting a reduced setback of 14.8 meters to that high water mark, So our zoning bylaw requires all structures to be set back 20 meters away from this high water mark. The dwelling will be 20.5 meters away from the actual shoreline of the property. So the variance is to reduce the setback to the high water mark, which is in the location of the interior side yard setback, which is this dark black line here that separates the subject lands from the immediate neighboring property. So the setback from the neighboring property is 20.47, or 74, sorry, meters. Just to give you an idea of the existing vegetation, this is looking at the shoreline. And another view of the subject lands along the shoreline. So as you can see, there is significant vegetation in existence. The original location where they complied with the zoning bylaw would require a lot of vegetation being removed. However, the revised location is on an area of natural bedrock, and I do have a photo here. So this is the stake of the boundary of the proposed dwelling. The area that complied is shifted about 6 meters further this way, so that would require all of these trees to be removed, and there is a steep slope here that was on the survey showing where the original cottage was going to be proposed in compliance. Putting the cottage here on this natural bedrock only requires some shrubs to be removed, and it will be less visible from the shoreline. This is the vegetation that separates the neighboring property from the subject lands, and this vegetation will remain to act as a vegetative buffer between the neighboring properties. And then just looking at view to the east. So the proposed dwelling will be located a little bit over to the right. The original site photos are from when the hold was going to be removed, and they were contemplating whether or not they would be able to put the dwelling in a location that complied. However, it was easier done on paper than the actual physical topography of the land, so that has brought them into the minor variance to revise their original location. To give you an idea of the cottage, it is a one-story cottage. And the floor plan. So on this lot, they would be permitted a maximum gross floor area of 268 square meters, and they are proposing 123 square meters. So the intent of the setback to the high water mark is to ensure buildings and structures are appropriately set back from the water. The required setback also provides for an area of vegetation protection, and it's to maintain an appropriate distance and elevations for structures from the high water mark. So the building is utilizing an area that's on a natural flat area and is less visible from the water than the original location that was in compliance with the zoning bylaw. The reduced setback is an area of low land between the two adjoining properties. So there is potential for water to come into this area during high water times. However, they are still maintaining an adequate setback from that high water mark of 14 meters. So the location is suitable to staff, and staff have recommended approval of the application. Site plan control will be recommended and has been addressed to the applicant, so they are aware of the process and the fees required with site plan control. So staff recommends approval of the application. The agent is present if you have any questions for him or if you have any questions for myself.
Thank you, Dana. Has there been any correspondence on this application?
3 letters of support were received by Paul Bastido, Adam Steiner, and Bill Sayers on behalf of Cognasheen Cottagers Association. 2 letters of objection were received from Janet and Marshall Gates and Pat Edwards.
Thank you. Is the applicant present? And would you care to add any comments to what Ms. Sunapee presented earlier?
James Barrow on behalf of Leslie Steiner.
I'm sorry, your last name again?
Barrow, B-A-R-R-O-W.
Thank you.
I think Dana touched every single point. I just had a couple points with regards to the letter that we did receive. The 4 quick points that were within that letter was the bylaw issue, whether it was major or minor. I think it's been clearly stated that it is a minor variance request. The water line issue, and I think this was discussed previously last year, there's a lot of areas that have a high water mark. However, they've been growing trees, shrubs. There's no beach sand. They're fully covered and aren't necessarily a water line anymore. Could they be at some point or another? Perhaps. But in this case, it's been overgrown since, well, I believe they bought the property in 1989. So the other two issues were the tree issue and septic issue. I think Dana has already explained it in clear detail. The proposed location is less invasive for taking care of the existing vegetation, and the septic issue noted was that they were worried about leaching into their property because it's downhill from where the proposed location is. However, it is the only spot in the entire approximate 4 acres where it's suitable to have the septic, which I'll note is over-engineered for full-time use and will likely be used less than 2-3 months per season. That's all I have to say.
Just for the purposes of clarification, Mr. Barrow, I didn't quite get the comment that you were trying to make relative to the water line. You're saying that, I assume we're talking about that 177.4 high water mark and that it doesn't come into effect or something there? Could you?
Well, no, it does technically because the survey carries the water line, high water line mark around. However, it's more, when we originally looked at relocating this cottage, we viewed it as an adjoining lot line. So your setback would be a lot less in this case. However, once we had the survey completed to plot the septic and the cottage on, we found out that the high water mark traveled around both sides on the adjoining lots. But as you can see from the pictures of the actual site conditions, it doesn't appear there was any water through there whatsoever.
If I may, I'm
Member Matthews.
somewhat familiar with the area, and it's a very low-lying, almost beach type of scenario. So I think it has sort of grown over, whereas if the water had stayed high, there would have been a slight river or creek, or not a canal, that's for sure. But I think it has just kind of osmosed over, probably. So that's what I think they're referring to as the water lot line. So, I don't know if that helps or not.
Could I just make a comment about the same subject, if you don't mind?
Yeah, sure. Go ahead.
Just in that, for clarification for Mr., is it Barrow?
Yes.
And you're the planner, is that correct?
No, I'm actually their builder.
You're the builder, thank you. Yeah, just for clarification, on Georgian Bay, we experienced an inordinately long, low water level. And as a result, we had growth like you're referring to here, that's in that area where it's under the high water mark. There's about 12, 14 years of low water, and then therefore a whole bunch of pine trees grew and all sorts of bushes and shrubs, and you think, how would the water ever come in here again? Well, I can guarantee you last fall in November and October when we had some huge storms, not only was the water in there, it was up to the high water mark and above that about 2 feet. So just for clarification, that vegetation eventually will, when the water stays up at this level, will probably die off because it'll rot. So just a point of clarification.
Okay. Okay, we may come back and ask you some more questions as we go along, but have you submitted all your comments then, Mr. Barrow?
Absolutely, yep. That's it for me,
Okay.
thanks.
Is there any other member of the public that wishes to comment on this application? Okay, then seeing none, I'll bring this application before the committee. Are there any questions or comments from the committee members? Member Cooper.
Thank you. Just questions for starters and then some comments, but I'm looking at this particular aerial photograph. I guess it's a satellite sort of shot or something like that. And I'm looking at sort of the middle portion of this lot, and I see rock barrens. And what I mean by that are the two spots that are sort of up from the shoreline. And so my point, I guess, is I just want to draw that to the attention of this group, because essentially, if the cottage was located on some higher ground and further back from the high water mark and more compliant, especially on the south side where we see that it's closer than it would ideally be, there is some high ground there. There aren't many trees that would have to be taken down, and so the structure could be located there. And so I just wanted to make that comment without much vegetation being removed. But I guess the other thing I'd like to comment on is we have some examples in the past that are similar to this that I have done a little bit of research, and wanted to submit this to the committee and also to the planning department to remind us of the decisions we've made before, because they can inform us and so forth. And in this case, it's not just the decisions we've made, but in fact, OMB decisions on a matter like this when we give a variance. And essentially, there's two decisions. One was in March of 2010, which was called Torrance Perks. And Torrance Perks was an example that happened in the Palisades Bay planning area. So it's sort of in Cognachine, but in Palisades Bay, and I think, in fact, was under the Cognachine planning rules at the time. And the finding, so basically somebody built in a similar fashion closer to the high water mark than is typically required. And a neighbor objected, saying that the setback could have been achieved, but it wasn't. And so the OMB in Torrance Perks basically found that says basically that where a 20-meter setback cannot be met, then then a lesser setback may be considered. But it went on to say that if you can meet the setback, you should meet the setback. So the decision is simply saying, if you can comply, you must comply. That is what the OMB found in the Torrance Perks case. So that's number one. Number two was...
Excuse me, Peter, what date was that?
I've got it in
March of... 2010.
It was called Torrance Perks. You can find it on the OMB site. The second one is more recent. It was 2016. It was another Cognachine OMB situation with Mr. Mark Kemmerer, and this was in the Cognachine area near the Musquash River. And essentially, Mr. Kemmerer built two sleeping cabins within the front yard setback. Not very much, mind you. I think it was sort of 18 meters back, and it should have been 20 meters back. And they were 10 by 10 cabins. And he built them on tent platforms, thinking, and was told by his builder, that he would be compliant if he built them where there were existing structures. He was incorrect about that. And unfortunately, what happened is that, or not unfortunately, I guess, the township called them out on this through the building inspector, and from a tip from a contractor that had a grudge. And essentially what happened is that went to the OMB. Mr. Kemmerer said, look, I'm almost compliant here. There's tons of trees. You can't see any of these buildings. And the township went, and the staff and the head of director of planning basically testified that the township never grants setbacks in the front yard unless, if it can comply. It just never does it. The testimony was that they never will do that, and which might be questionable, but nevertheless, that was the decision or the testimony from our planner. And what happened was the OMB made Mr. Kemmerer move his buildings. So we have a history here, and I'm glad to provide these to whoever would like to see them. or just put them on the record, but we have a history where if you can comply, you should comply. And that's what the OMB says. So I'm saying that I think there's an opportunity here to comply, and there may be some really, really incredible, compelling reasons as to why this can't comply, but I'm not getting them at the moment. So that is my 2 cents. Thank you.
Thank you, Member Cooper. Are there any other questions, comments about this application? Member Matthews.
Thank you, Mr. Hill. I guess I'm kind of on the same wavelength as Member Cooper. Dana alluded to it being a 4-acre parcel. The cottage is a modest size, which is nice to see. And I'm personally not convinced that putting it at the 20-meter setback would have a greater impact on the view from the canoe than it would where it's proposed. And I guess the other question I realize or see that Ms. Sotheby was able to have a site inspection in September, but we don't have that luxury now that it's coming forward to us in February. From my standpoint, I would support a deferral and chance and the opportunity to do a site inspection once the ice is out. Or maybe somebody wants to go by snowmobile, that probably by water would be more prudent. And because it just strikes me as a very, there's not many 4-acre parcels of land left in Cognachine that you can build a 1,300 square foot cottage or something rather. So it strikes me as a small cottage, large lot, and they're asking for a variance. That would be my suggestion, that we go for a deferral.
Thank you, Member Matthews. Are there any other questions or comments? Member Ferguson.
This application does have a lot of very positive features to it. I mean, the idea was to relocate the cottage to mitigate taking down a lot larger trees. This lot would provide for almost a 2,900 square foot cottage, where they're going for only for 1,334 square feet in a 1-story building. And there's no existing structure on the property now. So it's got a lot going for it. But on the other hand, I tend to agree with members Matthews and Cooper that if there is an opportunity to meet the high water, the 20-meter setback, then I think we should defer at least until a site inspection or until other alternatives can be fully investigated to move forward.
Another question from Member Cooper.
It's not really a question. I just wanted to say I support the concept of being able to inspect the site. In fact, I think that should apply to any water access property in the winter. I don't know why we're seeing these, to be quite honest. We need to see them in order to be able to judge whether there is, in fact, really a site that would work. And I think there are a lot of very positive things, and I don't want to really suggest that there aren't some very positive elements that were articulated here. It's simply that it's hard to make a decision about something like this when we haven't had the chance to be there. So I would very much encourage a deferral. I'm not trying to turn something down here without full knowledge, and that's where I'd like to be. Thank you.
Thank you. Thank you, Member Cooper. I just have one question. In regard to the contour that is being proposed for the new location of this, how many, what is the difference in elevation between the 178 high water mark and the proposed location?
Chair Hill, are you asking what the elevation of the proposed cottage is?
Yes.
One moment.
I think it would help if we knew what the proposed elevation is and what the 20-meter elevation would be.
Let me pull up the survey. survey here. So the elevation that's running through this cottage is 183, and this elevation that surrounds the cottage is, I guess, 182. And this elevation that's surrounding the cottage is 182. So 183 goes through it, and the 182 surrounds it.
Okay, so that, the difference between the high water mark and that's about 4 meters. What is the elevation at the 20 meter setback, at the one that would not require a minor variance?
This elevation that goes around here is 183, and the previous, which if I restart the slideshow, this previous location should show up. But this setback here is the boundary of that 20 meters, and there's that rock slope there. This contour here, that one. It's about 183 and 184 within the 20 meter setback from the high water mark along the interior side lot line.
So what we're talking in the difference between what is not, which would meet the zoning bylaw and not require a minor variance, is probably somewhere in the neighborhood of 2 feet? Half a meter? So, you know, and the reason I bring that up is to just in support of what Member Cooper, Member Matthews, and Mr. Ferguson are saying. You know, if we had the opportunity to do a site inspection, moving it back that short distance, and you know, which would result in a very minor additional height, you know, it may make sense just to build it, you know, where there's no variance required. But you know, we can't see it unless you know, we had special equipment to get out there. So I think the impression that I get is there's an appetite for a deferral on this, which I certainly support. And so if there are no more questions or comments from the committee, I'll read the motion. Be it resolved that the Township of Georgian Bay Committee of Adjustment approves minor variance A1845 to permit a decrease in the minimum required setback from the high water mark to the dwelling where 20 meters is required to 14.8 meters to facilitate the construction of a new dwelling pursuant to the Cognizine Shoreline Residential Island SR 17 zone of zoning bylaw number 2014-75 for 20 Island, 1900 Georgian Bay, subject to the following. A, that approval of this variance is granted and fixed to the subject site plan, extent, location, scale, and use contemplated in this application. That a site plan control approval application be submitted and approved, and that a site plan agreement be executed detailing the proposed development and vegetation protection areas in the manner prescribed by the applicable policies of the Township of Georgian Bay official plan as they relate to the administration of the site plan control, and that approval of this variance expires 3 years from the date of decision if building permits have not been issued for the approved structure. As I mentioned, I think we have an interest in deferral. I would ask the question, all those in favor of deferral, please indicate. Okay, this application is deferred. I just have a question for our planning department. relative to any application. If an application is deferred, is there a time limit on which this deferral lasts? Or does it stay deferred indefinitely?
Mr. Chair, there is no lapsing time period or sunset clause associated with that, so we're fine to defer it and consider it once you've had a chance to do a site visit.
Member Cooper.
I just wondered if it would be all right if we entered these two cases into the record for the planning department, so that it's available as part of the file that we're considering.
My recommendation would be to submit those electronically so that they can be distributed easily. If you have that.
I'd be happy to do that, but I'm also giving them a hard copy because it's highlighted, so it's also available, and I can send it to the.
I will pass that to our Secretary Treasurer for her disposal.
Thank you.
Mr. Chair, just one other item, Mr. Chair. Although there's no sunset clause, there are timing requirements that we identified last week in the Planning Act. So there are appeal opportunities if a decision isn't made within a certain time period. So that is available to the applicant. My experience is that it's very rare that an applicant would appeal based on a non-decision in the required time period, specifically when a deferral is being considered, and especially in this circumstance where it's clear that committee just wants to understand the lay of the land prior to making a decision. So I think that would be minimal risk. I thought it was important to add that as well.
Just while we're on that subject, because we've been in this situation before. When the weather permits, I would expect that certain members of the Committee of Adjustment would go and do a site inspection and would want to report back their findings. Is it then the responsibility of the applicant to take the next step if the application is deferred, or can the committee initiate a revisit to this particular application?
Just in terms of the timing to set when the next meeting would be, is that who establishes that? Is that what you're asking?
No, it's more of, in this particular application, the committee unanimously feels we do not have enough information to make a proper decision on this. In order to be able to do that, we need to go to the site. So let's say we all go to the site, we all look at it, and we want to to move this application further. Is that within our jurisdiction to move forward, or did we wait for the applicant to respond to that deferral? Like we're deferring it, can we bring it back before the committee at a later time is my question.
Yeah, like a future meeting would be at the Secretary Treasurer would identify that it's appropriate time to have a future meeting. Obviously, we're going to have discussions with the chair of the committee and then also with the applicant to make sure you've had that opportunity to review the site and they're comfortable with it moving forward.
Okay, Mike.
Well, I'm just wondering if we go out and do a spring site inspection, we could certainly let Lauren know that we've done our inspections, we're complete, and that may trigger her to start moving forward, or at least approaching the applicant saying, site inspection's been completed, let's move forward with the application. Would that work?
That's what I'm suggesting, absolutely.
And again, for clarity, Jamie, in previous situations where we have deferred an application, we've been fairly specific as to why that application is being deferred. And that gives the opportunity to the applicant to address that particular concern and then come back and say, okay, I've taken these steps to move this process forward. In this case, I think the exception or the reason for deferral is the question of whether or not that siting of that new cottage could be in such an area that would meet the requirements of the respective bylaw and no variance is required.
I think what the committee's asking for is an opportunity to do a site visit to satisfy themselves whether the variance meets the test of the, meets the 4 tests as outlined in the Planning Act. You have staff's opinion on that, you have the staff report. I don't think the staff report's going to change based on whether or not you do, the committee members do a site visit. But in this case, it appears clear to me that you are requesting deferral so that the committee members can do a site visit and get whatever peace of mind that's needed associated with that, and that's completely fair.
All right. Okay, we are on the same page. Comment from Member Cooper.
Just it's somewhat related. I made a comment earlier about my desire to see when we have water access applications like this, to be able to conduct a site visit. And so I think I want to sort of strongly express to our planning department that if that desire is there, then I hope that there'll be some consideration given so that we can make site visits. But the other thing I wanted to say is, and I'm not sure this is going to come up under the education section of our agenda, but I've made some inquiries in the last few days regarding the requirement to have something brought forward within 30 days to the Committee of Adjustment, an application being brought forward that's complete within 30 days. I've had 2 responses on that, and I'm hoping to have about 4 or 5. But the 2 that I've had, one is from these are all, by the way, from lawyers who practice planning law in Ontario. And the 2 that I've spoken to, one is in Toronto, one is in Mississauga, but I have others that are going to be getting back to me about this issue of timing. And in Toronto, I'm told by our representative there, our constituent actually, that's practicing there, says that the typical for Toronto is 3 months, and if it doesn't comply with the municipal law, Toronto doesn't care, and LPAT probably wouldn't do anything about it. That was the comment from this lawyer, because they said, you know, there's a high volume of applications, there are mitigating factors, and LPAT would say, you know what, you're just being troublesome if you're bringing this forward when Toronto is trying to busily work through its committee of its applications. In the other case, it was about 2 months was typical. So I raise this because in our particular case, I would hazard to guess that maybe 50% or more of our residences that we have in this township are water access. And so we need to keep that in the back of our minds in terms of being able to do site visits and consider applications in a very, very fulsome way. So I just, I'll apprise the committee once I get more information about what the practices are elsewhere, but I just thought it would be useful, since we had our education session, to make that comment, and I'll get back with further information. Thank you.
Thank you, Peter. I think a lot of us share the same thoughts, and you know, we'll give the planning department some time to consider that. I think our comments are duly noted. Are there any other questions or comments before we close?
Chair, could I interrupt and just point something out, please?
The chair recognizes
Thank you very much.
Ms. Gumby.
I just want to point out that when you have any questions about a specific application, all those questions should be asked during the meeting where the application is being heard, not after the decision has been made. Just to clarify that for the future. Even if it is a general question about deferral and the steps moving forward, that all needs to be done during the discussion on the application.
Okay, thank you for that clarification, Jessica. Any other comments?
Duly admonished. Just kidding.
Okay, it is now exactly 10:01, we're a minute over. That was because of Mr. Cooper. All in favor of adjournment? No?
There's a motion.
Oh, geez.
Can you?
In the minutes?
They have to deal with minutes first.
Minutes from last meeting.
How come you guys know so?
We're just here to support
Yeah.
the big guy, that's it.
Be it resolved that the Township of Georgian Bay Committee of Adjustment approves the minutes of January 18th, 2019 as amended and circulated. Any comment on that? All in favor? Thank you.
Okay.
Carried. Okay, that's the next one. Okay. We're gonna have to backdate this. Be it resolved that the Township of Georgian Bay Committee of Adjustment does now adjourn at 10:02 on March 15th. All those in favor? Carried.
Thank you.
I just want to mention that for the March meeting, I will not be present. But I will send an email to Lauren and the township, so you have a record that I will not be here.
That sort of brings up the question that we had before, last meeting. I'm going to ask that of the meeting.
Good, I agree. But you're right, it needs to be clarified.
Okay.
Am I signing something? Just approving the minutes.
Yes. So, okay, the meeting is over. We normally have an education section. Is there anything, Jamie, that you wanted to comment on in terms of
The meeting is over.
We adjourned it.
I know it. I just said that.
So you can't have education.
Oh, you can't have it. All right. Load up, let's go.
I would happy to transport anybody who wants to go to the site inspection. We can have time
Oh, yeah.
after April.
Yeah. We won't be able to talk to anybody, talk to each other while we're there.
Right, we've got to-
Is that correct, Jess? More education?
Even though the meeting is over, I will remind the members that I stated a few months ago when I was in Lauren's seat that there will be no more education, as typically it results in members discussing specific applications they've already made comments about during the decision. And if you have anything you need clarification on or you have questions of staff, feel free to email, and we will make sure to email you all back so you all have the right information. But education is not a common aspect in a Committee of Adjustment agenda, so we'll no longer be doing that.
Thank you.
Thank you, Jessica.
You're very welcome.
Could you be clearer on that?
Yeah.
I didn't think I could do, but I'll try. Yeah.
We adjourned, Mr. Chair?
Jessica?
I don't look at that chair.
No, you're not. The meeting's over.
You lied to us.
Yeah.
If that light's on,
Just on that point about the application, there are, during the course of a month, there's questions that come up when we're looking at these applications.
Yeah, and then you ask staff those questions when those applications are being raised.
And in terms of asking that, is it something that we should provide in writing, like in an email?
If you want to.
Yeah, and when
It's better to ask.
The training says